In this video, we'll discuss about law of tort, its origin and development. The very term tort was derived from the Latin term tortum, and tortum means any action or conduct of an individual if he is not straight or lawful, then it is called twisted or crooked. Such conduct or action is wrongful or unlawful. In French legal system, this is called tort, which in English legal system identified with wrong. The French-speaking lawyers and judges used this in the courts of Normandy and by the Angevin kings of England. In England, before the import of tort, it was procedure which was considered more important than right. Only certain royal writs were allowed to provide remedy for wrongful conduct. The plaintiff had to apply some correct and appropriate writs, otherwise such action for remedy was dismissed. This was governed under the principle of ubi remedium ibi jus, which means where there was no writ, there was no right. This form of remedy was based on procedural aspects and continued for more than 500 years until enactment of the Common Law Procedure Act in 1852, which abolished the procedure of filing appropriate writ for any remedy relating to any civil wrong. The Judicature Act 1873 and the rules made thereunder in 1875 accepted the principle ubi jus ibi remedium, which means where there is right, there is remedy. So, the very term tort is a French term, and it was derived from the Latin term tortum, and this tortum is nothing but consists some civil wrongs committed by an individual. So it is an action, and that action is otherwise called wrongful action or unlawful action. So whenever any action of an individual performed in a manner of twisted or crooked manner, then such action is considered as wrongful. So this system of French legal system was carried out by some judges and lawyers at the courts of Normandy during the Angevin kings of England. But actually in England, the very procedural law was continued for 500 years, and where the very maxim was ubi remedium ibi jus, which means where there was no writ, there was no right. And this system was a kind of legal procedure of filing writs to substantiate one's right. But in tort, the very legal maxim which is applicable is ubi jus ibi remedium, and which means where there is right, there is remedy. So, under this form, only pleadings containing statement in a summary form of the relevant facts is enough for any action in tort. In response to this development, the legislature enacted many pieces of legislation, such as Workmen's Compensation Act 1897, Fatal Accidents Act 1846, etc. And all these acts were enacted by the English Parliament to accept the maxim or principle of ubi jus ibi remedium, which otherwise means where there is right, there is remedy.